Hey everybody, I'm Rob Freeman and welcome back to Insuring the Built Environment. This week we're answering the question, what is a hold harmless and why is it important in the world of insurance? Well, a hold harmless is a common legal clause that you'll find in contractual agreements that are between multiple parties. So you may have an example would be like a lease between a landlord and a tenant, or another example would be in a construction agreement between, say, an owner and a general contractor or a subcontractor, or all three. And what a hold harmless does is it essentially shifts responsibility away from one party onto another party. And it's a very common thing to find in a lease. For instance, if you have a lease in an office building, you may find there's a clause in there which says something to the effect of the tenant agrees to indemnify, defend, and hold the landlord harmless in the event of any claims of bodily injury and property damage that might arise out of the tenant's operations. And so what's happening in that situation is that the tenant is taking full responsibility for anything that arises out of the tenant's operations. And if there was a claim, like say a visitor to the tenant's space went in and tripped over a power cord and injured themselves, say they chipped a tooth or something happened, whatever, and they filed a lawsuit against the tenant, and they also filed a lawsuit against the landlord. Well, in that case, the landlord is going to tender that lawsuit back to the tenant and say, hey, you agreed to hold me harmless, read this clause here, you take care of it. And that would be an example of how a hold harmless would work. And there's several types of hold harmless agreements. You have a unilateral hold harmless where one party is agreeing to hold the other harmless, and then you have a bilateral hold harmless, or what they call a mutual hold harmless, where both parties are agreeing to hold each other harmless and not sue each other or just take responsibility for whatever arises as a result of their agreement. And then you also have different types of hold harmlesses that vary by breadth. So you might have a limited form hold harmless where the party is taking some responsibility but not all. You have an intermediate, and then a broad form where under the broadest type of hold harmless maybe where the one party is agreeing to take responsibility for anything that happens, even if it results purely from the negligence of the other party. And that type of broad hold harmless could even be illegal in some states. So it's important to kind of think through the language of a hold harmless. Very important to have a hold harmless in any contracts when it comes to insurance. And you should work with your insurance broker to make sure that language is in your lease or your contracts. And because it can happen that in order to get good insurance, the insurance carrier is going to ask for a copy, say in a construction agreement, the insurance carrier is going to ask for a copy of the agreement between the owner and the general contractor or the subcontractor, and they're going to look for hold harmless language in favor of their insured. And what that means is that the insurance company sees that as a good risk management practice, because that's going to reduce the risk that the insurance carrier is going to be named in a lawsuit and may be found liable for, or their insured might be found liable for something that they didn't really cause. So in the case of a construction project, say a landowner hires a general contractor to build a building, the contract between the landowner and the general contractor should have a hold harmless in favor of the landowner in the event that somebody who's hired by the GC to build this building is injured on the job and then fires a lawsuit off to the landowner. And the landowner's like, well, I just hired this guy. I wasn't even involved. You deal with it. And so that's where that hold harmless language comes in, and it can be very valuable in not only protecting you from a lawsuit, but also helping you reduce your insurance costs. So anyway, that's what a hold harmless is. It's something that is a common risk management practice and a common legal clause that you find in many contracts. So if you have questions about contractual indemnification or hold harmless language in a contract that you're working on, feel free to schedule an appointment with me. If you're working on a large insurance project and you need to talk to somebody about this language, happy to try to help. Look forward to talking to you, and feel free to schedule an appointment with me at the link below. I hope this is helpful, and have a great day.